Good morning again, everyone. This case management conference is in the matter of case number CFI 012-2023 and is being held by way of video conference before Her Excellency Justice Maha Mheiri. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by NHB Limited and the lead counsel is Mr. Amr. The defendant is represented by MB Kemp LLP and the lead counsel is Mr. Sarah Mato. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
That's correct for the claimant.
It's correct from the perspective of the defendant. Thank you very much.
Thank you, Excellency.
Okay, you want to proceed?
If I may start, Mr.
Yes.
Moto, if Mr. Moto doesn't mind, I'll just brief Your Excellency on where we have reached. So at the moment, we've made attempts to agree on a CMC order, but we haven't been able to reach an agreement because there is a fundamental issue between the parties as to how these proceedings should proceed, in the sense that the defendants intend to file an application to ask the court to vary the manner in which the application, the proceedings should follow. In particular, the defendants are of the view that the nature of the claim does not require the usual evidentiary steps, namely production of documents and exchange of witness statements. Whilst we have had three without prejudice calls to try to bridge the gap between us. However, we haven't been able to reach a final conclusion on this point. So where we stand today is that we have submitted our version of the CMC order, which has the suggested dates, whilst the defendants have filed their own version, which, as you may have seen, it cuts down the procedural timeline to one submission per party and then a decision on paper by the court without a hearing. Now, we are not able to agree on this because there are evidentiary steps that we say are required. Essentially, we do need production of documents because our client wants to know which clients were exactly contacted by the defendants, and we'd like to obtain a list of those clients. We'd like to obtain copies of all the emails or WhatsApp messages sent to those clients, because this would help the court understand later on the extent of any alleged breaches to the confidentiality clause. And we cannot also do away with witness statements, because in light of the information that might come out in the production of documents stage, we might want to submit some witness statements. So this is where we are today. Now, practically speaking, given the fact that the other side intends to file an application to try to persuade the court to follow their proposal, I don't think that it's realistic for us to try to pinpoint any dates for further steps today, because if their application is successful, that might have an impact on the timetable. So what I would like to propose is that we agree on dates, on a timeline for the defendant to file their application, and then the usual timelines under the rules would apply for us to respond to that. And then once the court decides on that application, we can reconvene for a CMC and then take matters forward.
Your Excellency, if I may, on behalf of the defendant,
Yes.
I submit that my learned friend has misunderstood the position of the defendants. We intend to make this application orally before you today, Your Excellency, in respect of the matter before you as has been pleaded by the claimant. The matter that has been pleaded by the claimant is for a injunctive declaratory relief. The claimant, the case that has been advanced by the claimant against the defendants is for the court to determine the interpretation of a single term of the contract. The pleaded case that has been advanced by the claimant does not seek any production of documents concerning the emails or alleged contacts made by the defendants to any of their clients. In essence, if we look at the pleadings that have been submitted by the claimant, the case that's advanced by the claimant, it's clear that they're just seeking a declaratory relief from the court. Whether the clauses 15 and 17 of the two employment agreements essentially refrain the defendants from soliciting any of their clients of the claimant. And that is essentially what they're trying to basically ascertain from the court. What is the true meaning of that clause? So it's purely a legal inquiry. It doesn't require any discovery on facts. It does not involve any understanding of factual matrix, because it's the way the matter has been advanced. Unless my learned friend says that they intend to, I understand today, what's been suggested is that the claimant intends to vary the manner, vary their case. Then that requires for us to start the process altogether from the start. So our position is, and our application before you is that this is a matter which does not require any sort of disclosure, any witness evidence. In essence, this is an interpretation of a term of a contract, and anything that will happen will follow from that. So we respectfully say that the only thing that needs to be determined by the court is what is the meaning of the clauses 15 and 17 of the employment agreement of the two defendants. And that's what the claimant has pleaded. That's the relief they're seeking from the court. It is the reason why the court itself on the 23rd of May suggested to the parties whether they wish to transfer this case to Part 8 or before SCT, because the nature of the case, as has been clearly identified by the court, is that the claimant is seeking declaratory relief only, and that too on the meaning of a term of a contract. There's been no pleading and no particularization of the case that could involve any breach of confidentiality based on the contacts made by the defendants. That's not the relief the claimant is seeking. So we have to look at the relief that the claimant is seeking and move accordingly. And we say at present, on the case advanced by the claimant, the only thing that needs to be done is to determine the meaning of a clause which is common in two contracts, identical clause. And that does not require a hearing even, we say. We say that we can directly go from here to written submissions, and then for the court to determine the matter on papers only. This will be efficient, cost effective, and give clarity to the case advanced by the claimant. That's all we have to say for now, Your Excellency. Unless you have any questions at this stage, I will stop now.
Your Excellency, if I may comment.
Yes, please.
Yes. First of all, the email that was sent by the defendants to the registry with regards to this application did not mention that this application was supposed to be brought orally today. Hence, we are not prepared to address this issue orally, and therefore, we would request that if Your Excellency is minded to hear arguments on this point, then directions should be given to the parties to submit them at least in writing, and then so you would have the full picture. Having said that, in essence, what the defendants are trying to do is to re-articulate the claimant's case, because at the end of the day, it is the claimant who decides under which part of the rules it chooses to file its claim, and the rules provide for certain tools that are available to a claimant under each part of the rule. So the defendant's characterization of the claim, in our view, is wrong, because it is not about declaratory relief. The relief sought is of an injunctive nature. It's not a mere declaration. Secondly, there is an element of whether the entire issue relates to whether the use of the customer information and contact details by the defendants constitutes a breach of the confidentiality clause embedded within the employment agreements. So it is not a question of simply whether they're allowed to reach out to the customers. The issue is whether the use of the information for the benefit of a third party, i.e. their current employer, results in a breach. And if there is a breach, then whether that information, whether they can use this information to their benefit. So there is an issue between the parties here as to how the claim, what is the claim, which is not really an issue at this point, because at this stage of the proceedings, it is simply up for the claimant to articulate their case, and then the defendants would have an opportunity in their defense and later on in the trial, if there is a hearing or in written submissions, to provide what's their position on each head of claim. However, what the defense is trying to do at this point is recalibrate the claim in a manner that suits their position, and try to then change the RDC rules to fit their position. That's okay. But in any event, I do object to dealing with this issue orally today, simply because we were not given notice that was the intention, and we're simply not prepared.
Your Excellency, if I may comment,
Yes.
The issues that we are discussing today were articulated in our version of the case memorandum and list of issues, and my learned friend was served these documents in time, and we say that the claimant was well aware of our position that we are advancing today. In fact, we are not recalibrating or recharacterizing the claimant's case. If we simply look at the relief, Your Excellency, that the claimant is seeking in their claim form, in their particulars of claim, they are seeking a injunctive relief based on the meaning of clauses 15 and 17 of the two employment agreements, which two clauses are identical. In terms of the issue of disclosure, the defendants do not deny here that they have approached or dealt with some of claimant's clients. The defendant's position is that they are entitled to approach and deal with claimant's clients because the clause in the contract does not prohibit them in the first instance. And the second point we have on that is the clause in question that the claimant is relying on is unenforceable. So it's purely a legal question, what is the meaning of the clause, whether the clause entitles the defendants to use any of that information after the employment with the claimant. The defendants have not used any information that's listed in one of the reliefs sought by the claimant. So as such, in order to rule on the relief claimed, the court has to decide only on two of the following issues: whether the clause in the contract prohibits the defendants from dealing with and or soliciting the claimant's clients post-termination, and whether the clause in question is enforceable under the DIFC law. So we say that this is purely a legal inquiry, and the parties need not engage in disclosure witness statements and a trial, the purpose of which is to investigate disputed facts. The claimant's claim is not that there is a factual disagreement between the parties. The claimant's claim is that with the meaning that they give to clause 15 and 17 of the two employment agreement clauses, that they do not allow our clients, i.e. the defendants, to use any such information after the termination. We say that the defendant's approach reduces legal costs of both parties, is efficient, furthers the overriding objective, and gives speedy justice. And I'm sure my learned friend would like to understand the meaning of these clauses without any further delay. The fact that they're seeking an injunctive relief means that the matter is urgent, requires urgent determination. So we say the claimant should welcome the opportunity for the matter to be decided at the earliest possible opportunity. That's what we say, Your Excellency.
Your Excellency, before I indulge more in responses, may I ask for Your Excellency's view on whether this application can proceed orally today?
Mr. Salah, my recommendation is that you, or my direction, is that you file your application through the system, and with all its submissions to support that application, and then we give Mr. Amr time to properly reply to that application. And the CMC would be adjourned until we deal with the application for it either to be converted into a Part 8 or into the SCT, or stay in under Part 7.
Thank you, Your Excellency.
Your Excellency,
yes,
we wanted your directions on the issue raised by the court on 23rd of May, in which they have already given their suggestions that the matter might be better suited for a Part 8 or SCT procedure. Has Your Excellency given a preliminary thought to that?
Yes. Yes, Mr. Amr, as I looked at your claim form, it looks for me that you are only seeking declaratory relief from the court. Now, if there is another issues that you want the court to deal with, I would suggest that you provide a list of issues, because from the face of the claim form, it doesn't look like you are asking for anything else.
We have, I appreciate that, Your Excellency. We have provided a list of issues last week, and I'm happy to also write separately to Your Excellency and explain what are the issues, and perhaps this will be in any event in the response. Yes, so I can definitely clarify why is it not simply a declaratory relief.
Your Excellency, if I may, on this.
Yes.
The defendants cannot be expected to meet a threshold of a case if it has not been pleaded in the pleadings. On the case that has been advanced by the claimant, it is only seeking a declaratory relief, we say. So if they want to amend their case or change their case, there should be cost consequences for that. First point. And second point, list of issues is not pleading. They might have changed their mind and now said, oh, we have other issues that need determining also. But they have to be particularized and they have to be pleaded by the claimant, which we say at this stage have not been pleaded or particularized. So if they want to pursue new issues, that requires amendment or re-pleading of the matter. But that should not be without any cost consequences, because the defendants have so far invested their resources in defending a case advanced by the claimant, which is purely for declaratory relief.
Understood. Please, Mr. Salah, I would suggest that you file your application, and we will get the reply from Mr. Amr, and then the court is going to deal with that and deal with the cost issue in the same time.
We are very grateful, Your Excellency.
Your Excellency, just to be clear, is this application going to be filed as a Part 23 application and then the normal timelines would apply, or would Your Excellency give directions today as to timelines?
No, it's going to be dealt with as an heavy application, Part 23 heavy application.
Thank you.
Thank you, Your Excellency.
Is there anything else?
Nothing further from the claimant, from the defendants. I apologize. I beg your pardon, my learned friend.
Nothing further from us. Thank you very much, Your Excellency.
Thank you both for your time. Thank you.
Thank you, Your Excellency.